Hello, my name is Debbie Reynolds. They call me the Data Diva. Today, I want to talk about data privacy, the Digital Markets Act, and a current situation that's happening between Apple and Meta in Europe. So, the Digital Markets Act was enacted to create more fair competition in digital markets in Europe. So companies like Apple actually and Meta that are considered gatekeepers, they're supposed to be able to allow competitors to be able to make interoperability requests. So there may be for example, for Apple as a closed architecture, this has been a big deal because there are certain features and functionalities that Europe wants Apple and other gatekeepers to open up to competitors so that they create more level playing field. Apple is pushing back because Meta, up to this date, has made, they said, the most interoperability requests of Apple. I think it was like 15 or more requests. And Apple's concern is that the requests that are being made are for things or data that would not be, privacy preserving, and also things that wouldn't be even necessary for the types of use cases that Meta is asking for. So that may, for example, Apple is pushing back on requests, interoperability requests for Meta to access things like AirPlay, CarPlay, Wi-Fi settings, configurations, Bluetooth, things like that, because they feel like that information will provide some too much private information about an individual, especially in a way that is not necessary for the types of use cases that Meta is talking about. I think that we'll see these types of fights go on for quite some time. We know that Apple, as a closed ecosystem, has been, very protective of that, and so the fact that they have to even do these types of requests, I think, is concerning for them, especially as that the tightness of their OS and their ecosystem has created more privacy actually than people have had or experienced in maybe some of these other types of tools. But it remains to be seen how this plays out. We know that really the Digital Markets Act was really supposed to be something where a gatekeeper is supposed to help maybe a lesser known a company that could potentially be a competitor in some way, as opposed to probably not in this situation where you kind of have two gatekeeper companies fighting about interoperability. But it remains to be seen what happens with this. I'm very interested to see in how this plays out, because if companies are asking for capabilities or information that's really not directly related to a feature or functionality of an actual tool, that is a problem. And I think what is needed here probably is more clarity from the EU on the types of requests, and especially in a situation where someone or a company is asking for something that would create a privacy harm to someone, but then also something that maybe is not even necessary for what they're doing. So, in my example, I would imagine this would be almost like your flashlight wanting your access to your address book, right? So that would be something that wouldn't be privacy preserving, right? Wouldn't have a good use case and a good excuse or reason to be able to share that information. But those are the types of things that you get into with laws like this, especially as they're well intended about interoperability and may not be being used in the way that maybe legislators, regulators had imagined. So I'm very interested to see what the EU has to say about this, because I think it's actually a pretty good question, and it's something that probably needs more clarification in the future. That's it. Thank you. Bye.